Hello everyone. In this presentation, we will analyze the various rules pertaining to punishments as provided under the Indian Penal Code. As we all know, punishment is the sanction imposed by law for violation of rules laid down by law. It is inflicted on the person or property of the accused. The punishment aims at protecting the society from mischievous elements by deterring potential offenders, preventing actual offenders from committing further offenses, eradicating evils, and reforming criminals and turning them into law-abiding citizens. The quantum of punishment inflicted in all cases is not uniform. It depends upon a number of factors like the nature of the offense, intention, age, and mental condition of the accused, and the circumstances under which an offense is committed. There are two dimensions to punishment. There has to be a purpose which justifies the punishment. The nature and quantum of punishment must be proportional to the nature and seriousness of the crime. Based on the purpose which justifies the punishment, there are four basic theories. Retributive theory, which emphasizes that the nature and quantum of punishment should be such as to satisfy the feeling of vengeance of the victim, failing which people will take law into their own hands to take revenge against the wrongdoer. Deterrent theory, which emphasizes that the punishment should be such as to threaten the prospective offenders and actual offenders from further committing crimes. Preventive theory, which emphasizes that punishment should be such as to incapacitate the offender and thereby prevent him from further committing crime. Reformative theory, which emphasizes that the aim of punishment should be to reform the criminal and reintegrate him into the society. However, a perfect system of criminal justice cannot be based on any single theory. It has to be a combination of all. The general provisions relating to punishments that can be imposed under the Penal Code are contained in Chapter 3, running from sections 53 to 75. Section 53 provides for 5 types of punishments that can be awarded for offences under the Code. They are death, imprisonment for life, imprisonment for a term either rigorous or simple, forfeiture of property, and fine. Transportation for life or for a term where the offender would be sent out of the territory was abolished after independence. The code does not in general provide for a minimum penalty to be imposed. A wide discretion is given to the courts to decide each case on its merit, subject to the maximum limits of punishment prescribed for the offences. Sentence of death is the most extreme punishment under the code and is sparingly inflicted. The offences for which death sentence is prescribed as an alternative punishment are waging war against Government of India, abetment of mutiny when mutiny is committed, murder, dacoity accompanied with murder, attempt to murder by a life convict, abetment to suicide of a minor, insane or an intoxicated person if such person commits suicide, aggravated forms of rape, and for giving false evidence with an intent to get an innocent person convicted of capital offence and that innocent person gets convicted and executed. Though the question whether or not death penalty serves any penological purpose is a difficult and complex issue, there is reluctance to do away with it due to different social conditions. Imprisonment for life means a sentence of imprisonment running throughout the remaining period of convict's natural life. Imprisonment for life means rigorous imprisonment for life, that is, imprisonment with hard labor, conspiracy to wage war, preparation to wage war, sedition, counterfeiting Indian coin, culpable homicide not amounting to murder, dowry death, and dacoity are some of the offences punishable with imprisonment for life. Imprisonment for a term may be of two kinds, rigorous and simple. In rigorous imprisonment, the prisoner is subject to hard labor, while in simple imprisonment, lighter work or sometimes no work at all is taken from the prisoner. The Penal Code prescribes that rigorous Imprisonment for a term has to be awarded in the case of certain offences like robbery, rape, etc. In the case of certain others, the sentence prescribed is only simple imprisonment like defamation, wrongful restraint, etc. In all other cases where imprisonment is prescribed as punishment, it is of either description and the judge has discretion to award it based on the facts and circumstances of the case. In certain cases, the minimum imprisonment that has to be imposed is prescribed by the code. For example, in cases where while committing dacoity, the offender uses deadly weapons or causes death or grievous hurt to any person, a minimum of 7 years imprisonment has to be awarded. In all other cases, the code prescribes the maximum imprisonment that can be awarded and discretion is given to the judge to award a sentence within the limits prescribed in the section. Forfeiture of property as a punishment is of very ancient origin and it can be inflicted under 3 sections under the code. 1. Property used for committing depredation on a territory at peace with Government of India. Property obtained by war or by depredations committed under sections 125 and 126 of the Penal Code. Property which was unlawfully bid or bought by a public servant which he is legally prohibited to bid or purchase. Fines can also be imposed as punishment. The rules pertaining to imposition of fine as punishments are: 1. Fines imposed may be limited or unlimited, but it should not be excessive. There are offences which are punishable with fine only, example, polluting the atmosphere, etc. There are certain offences which could be punished with imprisonment or fine or both, like theft, mischief, etc. There are certain offences which could be punished with imprisonment as well as fine, like rape, robbery, etc. Maximum amount of fine that can be imposed may be specified by the code or may be left to the discretion of the court trying the offence. For calculating fraction of imprisonment for life has to be taken as 20 years imprisonment. When the offence is punishable with imprisonment of either description, the court has to specify the description of the term of imprisonment, that is, whether it has to be rigorous or simple. When the offence is punishable with fine, the imprisonment that has to be undergone if he is unable to pay the fine has to be specified. When the offence is punishable with imprisonment and or fine, the imprisonment that can be imposed in default of payment of fine should not exceed 1/4 of the maximum term of imprisonment that can be imposed for the offence. Where the offence is punishable with fine alone, imprisonment can be imposed in default of payment of fine, which should not exceed 2 months when the fine imposed is up to ₹50, 4 months when the fine imposed is between ₹50 and 100, and up to 6 months when the fine imposed is above ₹100. The code also provides for commutation of sentences, that is, altering the punishment. Death sentence can be commuted to any other punishment by the appropriate government. Here, the central government is the appropriate government in the case of central laws and the state government in the case of state laws. Imprisonment for life can be commuted to imprisonment, rigorous or simple, for a term not exceeding 14 years by the appropriate government. Again, central government for central laws and state government for state laws. When a person is sentenced to rigorous imprisonment for a term, the court can order that the prisoner be kept in solitary confinement for a portion of imprisonment to which he is sentenced. The intention was that when a person was solitarily confined, without allowing him to mingle with other inmates in jail, he would have time for himself to introspect and repent for the offence committed. But man is a social being, and this isolation in a cell for a long period had evil effect on his mental and physical health, and hence certain time limits have been prescribed beyond which a person cannot be solitarily confined. Solitary confinement should not exceed 1 month when the term of imprisonment is up to 6 months. It should not go beyond 2 months if the sentence of imprisonment is between 6 months to 1 year, and it should not exceed 3 months if the sentence of imprisonment imposed is more than 1 year. Therefore, solitary confinement cannot be imposed for more than 3 months in any case. In addition, when imprisonment awarded is for not more than 3 months, solitary confinement should not exceed 14 days at a time with 14 days gap or interval between two spells of confinement. If the imprisonment awarded exceeds 3 months, solitary confinement should not exceed 7 days at a time in any month with an interval of 7 days between two spells. The code also prescribes enhanced punishment under section 75 when a person is convicted of any offense punishable under chapter 12, that is offenses relating to coins, and chapter 17, that is offenses affecting property, with the imprisonment for not less than 3 years if he was previously convicted of an offense punishable with imprisonment for not less than 3 years under chapter 12 and 17. The offense need not be the same but must be an offense falling under chapter 12 or chapter 17 and must be punishable with imprisonment for not less than 3 years. The enhanced punishment would be imprisonment for life or rigorous or simple imprisonment for a term which may extend to 10 years. The idea behind inflicting enhanced punishment is to discourage habitual offenders by providing deterrent punishment. This, in brief, is about the rules pertaining to punishments that can be inflicted under the Indian Penal Code. Thank you.